Hello everyone, and welcome to Mercer Capital's webinar, Pierce versus Commissioner, Valuation Perspectives for Advanced Estate Planning Professionals. Our presenters today are Travis Harms and Tim Bronza. Travis is the president of Mercer Capital, and Tim is a managing director in the firm's gift, estate, and federal tax valuation practice. Both Travis and Tim bring extensive experience in valuation for advanced tax planning. You can learn more about their backgrounds and experience on Mercer Capital's website, mercercapital.com. Before we dive in, let's review a few housekeeping details. For any technical difficulties, notify us using the chat box. For questions about today's presentation, use the Q&A box. We will address your questions at the end of the webinar. In the Resources tab, we've provided additional materials, including a link to the Pierce case. Finally, to meet CLE requirements, several poll questions will appear during the webinar. Please select your response and click Submit each time. Now, I'll turn things over to Travis and Tim.
Thank you, Missy, and thanks for all of our attendees for joining us today. We want to talk about the Pierce case. And the first question that we should probably ask ourselves is, why do we want to talk about the Pierce case? And we think it's important because this case really signals the tax court's willingness to engage with valuation reports at a very, frankly, detailed and granular level. You know, tax court cases are always fact specific, but Pierce is especially instructive for both appraisers and estate planning professionals who are seeking accepted as filed outcomes in material transactions. Now, there are some things in this case that the appraisers did really well, and there are a few places where each one of them falls down a bit. And we'll talk about those as we go through the case. So today we want to cover a few key topics, and we'll spend the bulk of our time talking about the tax court's analysis of the appraisals. And the tax court went through line by line on 7 different aspects of the income approach used by both appraisers in this case. Now, we won't belabor all 7 of those, but there are 3 issues that really are critically important and that we'll spend a little time talking about and giving our perspective on the facts of the case and how the tax court interpreted those in the context of what's going on. So, the first thing that really struck us when we read the case is the importance of what we'll call, for our purposes here, narrative coherence, and how that contributes to the credibility of valuations. So when you look at the case, it's a 45-page case, and over a third of the case is really just giving the company history and providing some key developments that are leading up to the valuation date. And we won't rehearse all of that here, but suffice to say, this business that's at the subject of the case, Mother's Lounge, is a unique business. It was started by a young couple who had a clear entrepreneurial spirit, and they had struggled and had frankly failed at several business ventures before they really found their mark with Mother's Lounge. And the secret that they found and the formula for their success was in the market for mother and baby goods. And they would go to trade shows and they would find products that were in the market and that were successful. They would manufacture knockoff and very cheap versions of those products. And then they would sell them under what they referred to as the free just pay shipping model. So with coupon codes that they distributed liberally through various channels, they would attract people to their website who would enter the code to get the product for free in exchange for just paying the shipping. And the shipping rates were, of course, inflated to provide enough for the business to cover the cost of manufacturing and the cost of shipping and leave them with a profit. And this formula, once they hit upon it, was immensely successful. Within 4 or 5 years, they had grown to a business that was doing over $20 million a year in revenue. So things were going very well. but there were some clouds on the horizon. A lot of the marketing strategies that they had pursued were beginning to reach their end. Product quality was low, the customer experience was not favorable, and as the world moved to more social media-based marketing, that did not bode well for the company because they really couldn't rely on positive word of mouth from their customers. Moreover, they were exposed to threats from litigation as they were effectively pirating other people's products, and that eventually led them into some hot water. And then finally, the marriage itself entered into a difficult time with some infidelity, and that since the husband and wife were working together in the business, that created some business struggles as well. So, Tim, as we think about some of the, key takeaways for advanced estate planning professionals when it comes to getting the story straight, thinking about valuation is not just about the numbers, but is about building a persuasive case for the reader of the valuation report. What are some thoughts that you might be able to share with us around that?
Well, you really can't overstate the importance of getting the story straight. And fundamentally, valuation is about two things, right? It's about the numbers or the quantitative analysis, but it's also about, and maybe more importantly, in my view, communication, how you communicate that conclusion of value. And um, the Pierce opinion is a really good example of a story intensive scenario that actually both appraisers that testified in this case and the tax court delved into to a significant amount, which led to the valuation analysis and ultimately the conclusion. I think the important takeaway here is that this story really begets the numbers, and both of them have to be consistent for the valuation to be persuasive and realize the favorable outcomes related to the opinion.
Yeah, I think in this case, especially it really goes to that telling that story is not just a matter of reciting facts, but tying those facts into creating a narrative around those facts and tying that narrative to the valuation itself and making sure that there's a clear link between the story that you're telling about the business and the valuation methods, approaches, assumptions, and most importantly, conclusions that you're deriving with respect to the subject interest.
I'd also like to just mention, Travis, that I firmly believe that estate planners are uniquely qualified to, critique valuation reports and valuation analysis. I mean, they've got critical thinking skills that are developed maybe in a little bit other areas, a little bit more frequently, but certainly have the critical thinking skills to dissect the important points of the valuation analysis and really evaluate whether that story is, persuasive or not.
Exactly. All right. Well, let's dig into those numbers. Let's talk about what was at stake in this case. The IRS conclusion was about 50% higher than the taxpayer's position. And in the terms of the magnitude of the dollars at stake, that was about a $3 million delta between the two valuation conclusions. And the chart on the right here shows for one of the two interests that were at the heart of the case. There was a gift and there was a sale. The 29.4% gifted interest, the taxpayer valued at 3.9 million and the IRS valued at 5.7 million. In terms of the business as a whole, the both appraisers relied exclusively on a discounted cash flow model under the income approach, and the taxpayer's conclusion of the value for the business on an operating basis was 17.3 million, and the IRS was at $25.9 million. Interestingly, the original Form 709 filed at the time of the gift was for a higher number, about $4.9 million for this 29.4% gift interest. And that really kind of speaks to the fact that clearly that appraisal was not accepted as filed, and that led to the subsequent litigation.
Yeah, I
So,
think,
yeah, go ahead, Tim.
yeah, I think the other observation here is not really related to, the specific thrust of this case, but these aren't the largest value differ or total value differentials that we've seen in practice in terms of examination. So it's somewhat of conjecture as to why, this made it all the way to a tax court opinion. But it's worth noting, at least the examinations that we've gotten involved in, the value differentials or the materiality, I would say, of the matter seems to be somewhat higher.
And interestingly, the opinion does mention that, so as we've said, this was a husband-wife team of entrepreneurs, and the taxpayer in this case is the husband. The wife had made a set of mirror gifts at the same time, and the wife settled with the service prior to trial. So the trial only related to the husband's interest. All right, so let's look at the tax court's analysis in a little more detail. Uh, the Pierce case, again, is interesting because the court ultimately elected to evaluate at a very discrete level 7 components of a discounted cash flow analysis. So the court never really addresses the overall conclusions of value. Instead, they're very focused on these 7 components of a discounted cash flow analysis. Obviously, the first component and the most significant one is the cash flow forecast itself. And there are 2 forecasts in play in the case. And it's interesting that the appraiser for the taxpayer had actually prepared both forecasts. So as we mentioned before, there was an original appraisal that was prepared at the time of the gift. Then when the gift was under examination, so in 2017, the gift was in 2014. In 2017, the gift was under examination, and at that time, the taxpayer retained a different expert to generate a cash flow forecast that would reportedly be used by yet another expert to prepare a valuation. And now, there's nothing in the record about that second valuation ever being prepared. However, this forecast did make it into the record, and the IRS relied on this 2017 forecast for its analysis. Now, that same appraiser who prepared the 2017 forecast was also retained subsequently by the taxpayer to prepare the valuation that was presented to the tax court. So at the time of preparing that valuation, the appraiser developed a different forecast for use in the valuation. So that's referred to as the 2024 forecast. So we have 2 forecasts, the 24 forecast and the 2017 forecast, both of which are prepared as of the date of the gift, which was in June of 2014. So the court ultimately sided with elected the 24 forecast as the most representative of what was known and reasonably knowable at the valuation date. The court was really critical in its opinion about the IRS expert adopting the 2017 forecast without really doing any independent work to verify that that was a reliable forecast for use in the valuation. So what do these forecasts look like? They tell very different stories about the future of the company. In our charts here, we've got a chart on the left, which shows sales under both forecasts. The dark blue bars are the 2024 forecast, which is what the court ultimately accepted. The brown bars are the 2017 forecast, which again was prepared by the same expert, but at a different time and for a different purpose. And the court ultimately rejected that. Well, when we look at the sales forecast there on the far left, that shows that the 24 forecast shows sales continuing to grow. We have a business that went from essentially no revenue back in 2009 or so to over 20 million in 2013 and was expected to generate over $30 million of revenue in 2014. So the 2024 forecast shows that revenue growth continuing subsequent to the valuation date, while the 2017 forecast shows that revenue would decline following the valuation date. When we think about margin, that's the middle chart on our slide here. Margin is deteriorating rapidly in the 2024 forecast. So the company had been quite profitable. EBITDA margin in 2013 was 27+%. And both forecasts show margin declining over the forecast period, but the 2024 forecast anticipates a much sharper decline in margin. So when we look at the chart on the far right, which is actual dollars of EBITDA in the forecast, when you combine a higher revenue forecast with a lower margin forecast, you end up with with EBITDA forecasts that are not terribly dissimilar. There's clearly a difference in 2016 and 2017, and that difference persists in 2018 and 19, but is much smaller. So despite telling very different stories about the company's future, both forecasts kind of landed in a similar spot when it comes to actual dollars of profitability. Now, Tim, when we think about some takeaways for advanced estate planning professionals around this issue of the forecast, what are some of the primary issues that stand out to you?
Well, as the slide indicates, the story that's laid out in the narrative and the business description have to match up with the methodology and make, ideally a segue between historical performance and into future performance, really making that transition, kind of hang together basically. I think the other thing and the reason that the court favored the 2014 forecast was that the appraiser for the taxpayer corroborated that forecast with some pretty on-point industry data. Whereas I believe that the Internal Revenue Service taxpayer didn't have as robust of what I would call corroborative evidence. So this begs to the issue of, what is the appraiser's responsibility in terms of information that they rely on that's prepared by third parties, or in this case, I guess it was a little bit unusual that the taxpayer's appraiser relied on his own forecast. But and it's really to try to, as much as possible, provide corroborative evidence or some type of capital market evidence to support the conclusions. One thought in terms of performing income approaches generally that estate planners can be aware of is that frequently in the valuation of a company, company principals will provide appraisers with management budgets or forecasts, which in the execution of an appraisal, most appraisers, I think, would put, quite great weight on those kind of management developed forecast and budgets. Having said that, you can't take those that financial information and forecasting without some type of corroborative procedures, because there may be some motivations on behalf of management to present a budget one way or the other. And so it's important that the appraiser really focus on some type of independent assessment of that information that is obtained from third parties.
Yeah. And in this case, I suspect perhaps the IRS expert may have felt like he had a free pass given that the forecast was prepared by the appraiser for the taxpayer. But the court really did not view it that way and certainly critiqued the IRS valuations experts' failure to really perform any sort of independent procedures to verify that forecast that he ultimately relied upon. All right, so the next issue is one that going all the way back to the Gross case earlier in this century is around tax affecting for tax pass-through entities. So Mother's Lounge was a tax pass-through entity, and courts have wrestled with that issue in a number of cases over the years. In Pierce, both the expert for the taxpayer and the expert for the appraiser elected to tax affect the earnings, and they did so using similar models and substantially equivalent rates. So, since the evidence presented to the court in this case reflected both experts applying taxes to those ex corp earnings, and they even used the same model, the court accepted that treatment. Now, the court was very clear in its opinion that while it was accepting that treatment in this case, it was not issuing a blanket approval of tax affecting being appropriate in all cases. So, Tim, as we think about what are some key takeaways or observations that you might have around this issue of tax affecting, and what, if anything, we can learn about tax affecting from the Pierce case?
Yeah, I think it's very similar to some of the other issues that are addressed in this case and just generally valuation practice. In order to have your opinion accepted, you have to work for it. You have to provide good, solid analysis and capital market evidence and rationale behind what you did, and importantly, explain that in the written report, which constitutes your direct testimony in tax court. I think also doing that really helps, even if it doesn't make it to a litigated matter, it really helps um, achieve accepted as filed opinions or resolutions, excuse me, or if it is examined, the matter, it'll provide you as the estate planner arguing this the sufficient fodder to settle the examination at a favorable level. So if you read through the opinions that have come out since the Gross opinion, which is now, 25 or 26 years ago, a thread has evolved, and it really revolves around two major concepts: um, tax affecting, and then determining whether or not the pass-through entity status is favorable, unfavorable, or is kind of a wash. So on the first point, the appraiser must explain in sufficient detail the reasoning behind their tax affecting. And most of that reasoning really revolves around the fact that the rates of return that appraisers use in their execution of the income approach are derived from the public markets. Now, all those companies, as everyone knows on this webinar, are C corporations by definition. So in order to properly get to a pass-through entity conclusion of value, the appraiser is going to first apply the income approach, which is going to be at a C Corp equivalent level. So you want to really nail down the reason why you tax affected. And then the second component of this is the analysis of the pass-through entity status, whether it's an S corporation, which you see more often, or partnership status. And there are various models. Many of them have the same type of attributes, but they really look at certain things, distribution policy and basis buildup, a number of different factors to determine kind of quantitatively whether or not, based on the future outlook for the company, whether or not the S Corp status is a positive attribute, a negative attribute, or maybe it's about the same. Now, in the current environment, we are basically seeing those positive attributes kind of going away in our analysis, and that's because of the impact of the 2017 Tax Act. Now, this probably discussion goes a little bit beyond the scope of this particular webinar. However, um, when you're looking at these appraisals and you're looking at the past serenity analysis, you want to make sure that the rationale behind um, whether or not the past serenity analysis is positive, negative, or a wash is supported by logic and reasoning that hopefully again is persuasive with the parties that are going to examine these submissions.
Very good. And while the tax court was excuse me, unwilling to blanket endorse tax affecting, the opinion certainly signals that, hey, if given sufficient reasons, tax affecting can be accepted. So let's move on to the third and final significant issue in this case, and that is the discount rate. So on the matter of the discount rate, the IRS and the taxpayer took different approaches. IRS expert derived an 18% discount rate using a build-up method and declined to apply any specific company risk. The taxpayer expert, on the other hand, reached a 17% discount rate through its build-up approach and then applied a 5% company-specific risk premium to derive a total discount rate of 22%. So when the court looked at those two approaches, those two elements of the discounted cash flow model, and weighed the merits of the two, the court ultimately sided with the IRS expert and declined to accept the 5% company-specific risk premium that was applied in the taxpayer's valuation report. So when we look at the taxpayer and the IRS and their valuation experts, how they address this issue of the company-specific risk premium, the taxpayer's report did lean on a lot of those factors that had been described in the company narrative. They identified 5 factors that they said were not applicable that were not already reflected in the base discount rate, which was ultimately drawn from larger companies. Those 5 are listed on the slide here. They were potentially going to lose a significant contract that drew a lot of business to them. There was obviously some discord and mistrust from the marital issues that had arisen prior to and at the valuation date. There was risk from a lawsuit from a competitor. There was some uncertainty about how long this free just pay shipping model would last. Again, the opinion makes it clear this was not really a customer-friendly model, and without positive word of mouth, without positive customer experiences, one would perhaps question how long they can keep that up. And that also spills into the 5th factor there, the reticence to adopt social media. So in the early 2010s, things were definitely moving to, hey, have a Facebook page, have forums where customers can comment about their experience with your business and with your product, and that's obviously not something that the business owners in this case were willing to embrace. So, in my view, the taxpayer's expert did a good job of identifying, hey, these are the risk factors that we believe are incremental to the risk factors that are reflected in our build-up method. Where the taxpayer's expert seems to have fallen short in the eyes of the court is that the selected risk premium, there was no firm basis for why it was 5%. So could it have been 3? Could it have been 7? You know, uh, the IRS expert, on the other hand, of course, I think characterized company-specific risk by say somewhat pejoratively by saying that the risk premium could not be, quote, fully explained mathematically, and inherently relies on his own subjective interpretations of the circumstances. So when the court kind of weighed these two views, the court was ultimately unimpressed with the taxpayer expert's inability to say how he derived a 5% premium and why 5% was a reasonable premium as opposed to any other number. And with the court unable to understand a calculation behind that number, they said the opinion says that they found the taxpayer expert's explanation to be wholly deficient to gauge the reliability of the 5%. So, Tim, when we think about this issue of company-specific risk, and it's a thorny one for appraisers and for readers of appraisal reports, what are some of the things that our audience should take away from the Pierce case?
Yeah, so on the company specific risk premium, I think this is one of the big takeaways here and really is a fundamental paradigm relative to the valuation of closely held business interests. You must present capital market evidence that's related to what you did. I would say, it kind of goes back to the story and the numbers. I think the appraiser for the taxpayer did a+ job at enumerating the specific risk attributes of this company, yet provided zero capital market evidence to support the 5% adjustment. And if you do that, if you go through that process, you're going to lose every time. You've got to provide some type of evidence for what you can't just say, it's in my opinion. And now, having said that, the company's specific risk premium is one of the most challenging aspects of valuing privately held companies. We know that it exists. Reference anecdotal evidence of transactions involving transaction multiples of larger companies versus very small companies. Very small companies do not garner the same type of multiples that larger companies do. And because this issue is so challenging, you really have to build up. There is no really, at this point in time in the financial valuation community, really any on-point data to tie these specific risks to capital market evidence directly. But there are methodologies and approaches that might be considered to support such an adjustment. Number one would be the anecdotal evidence that I just mentioned between relative to transactions of larger privately held companies versus smaller companies. There are some miscellaneous studies that have been written on there, which if you read through those, they basically all support the notion of a company specific risk premium. Do they provide the direct on-point capital market evidence? No, but it's supportive of the overall gist of applying a specific company risk premium. And then also in the financial valuation community, there have been some miscellaneous tools that have been developed over the years to try to quantify this, notably the Butler-Pinkerton model. And there's this also this method, the implied private company pricing line, which are worthy of investigation. At the end of the day, if you tell a great story, but you don't have capital market evidence, you're going to lose every time.
Yeah, I think in this case, the taxpayer's expert at trial, I think, attempted to quantify he quantified the effect of the premium. So that's a step in the right direction. So he was able to tell the court the 5% risk premium in my buildup, in my discount rate, reduces my conclusion of value by 19%. Like I say, that's a step in the right direction, but a 19% discount in and of itself doesn't have any meaning, doesn't tell the court anything because it's not clear what that discount is from or what the resulting conclusion of value is. So, Tim has mentioned the importance of capital market evidence, and I think expressing the conclusion of value in terms of a multiple of EBITDA or some other measure that would allow you to incorporate capital market evidence into your analysis and show that you have, in fact, assessed the overall reasonableness of the valuation conclusion. In this case, neither side seemed to address, okay, what does this conclusion of value mean in terms of, for example, a multiple of EBITDA? I think that would have perhaps been more persuasive to the court than simply saying 5% equals a 19% reduction. Because again, a 19% reduction in value in and of itself doesn't mean anything. We don't know to what value that 19% is applied, and we don't know what the resulting value is, again, in terms of a relative value measure like EBITDA. So,
Yeah, just one other comment here on this, Travis. So for the planners in the room, you might think about it from a kind of a hierarchy of evidence. Direct capital market evidence is always going to be the best approach. But for some of these issues that really, we're in the world of private company valuation. By definition, private companies don't um, information relative to their financial affairs and transactional data largely is not in the public domain. So it makes it really difficult to find on-point capital market evidence to support certain valuation contentions in the valuation of privately held business interests. So for an issue like company-specific risk premium, you try to get as much on-point capital market evidence, which is really sparse. And then the other kind of set would be corroborative evidence, anecdotal evidence that really supports the entire argument that the appraiser is laying out in their opinion.
very good. Thanks, Tim. So let's move on from the discount rate, and the next four elements of the valuation receive a little less airtime in the opinion, but they do affect the conclusion nonetheless. The first of those is a terminal growth rate. So as we know, when you're using a discounted cash flow method, which both appraisers did in this case, you have a discrete forecast of what the cash flows will be over some finite period. And then you have to make an assumption as to the rate at which those cash flows will continue to grow following that discrete forecast period. In this case, the taxpayers expert assumed a terminal growth rate of 3% per year, and the IRS assumed a terminal growth rate of 2% per year. The court selected the taxpayers' terminal growth rate as being more consistent with long-term GDP growth. Now, what's interesting, I think, in this context of this case, is that the taxpayer was actually assuming a higher growth rate than the IRS. So by selecting the taxpayer's growth rate, the court's selection of that number was actually favorable to the IRS because it, all else equal, increased the conclusion of value in the court's opinion. Tim, you have any thoughts on long-term growth rates?
No, I mean, it seems like the court's opinion here was more in line with terminal growth rates and, that I've observed over the years and in various anecdotal evidence and direct capital market evidence. And obviously I think they were more persuasive here than the IRS appraiser.
Yeah. The next issue was around non-operating assets. Um, so the company, both appraisers agreed that the company had excess working capital at the valuation date. The only dispute among the two was how to quantify that excess working capital. The taxpayer's expert estimated their working capital needs with reference to the sales volume of the company, whereas the IRS estimated working capital needs with reference to the assets of the company. And the tax court ultimately found that that tying working capital needs to sales was a more reliable basis for estimation than tying working capital needs to the asset base of the company. So whereas the taxpayer appraiser said there was $1.35 million of non-operating or excess working capital, the IRS expert concluded that that number should have been 2.22 million. So you've got about nearly a $1 million difference there, and the court sided with the taxpayer and the lower balance of excess working capital. The next issue is the discount for lack of control. The taxpayer applied a 5% discount for lack of control to the conclusion of value that they derived under the income approach using the discounted cash flow method. The IRS expert, on the other hand, applied a 10% discount, but only to the non-operating assets. So the IRS expert was effectively saying the results of the discounted cash flow method are already on a minority interest basis, and therefore no additional discount was required to move from a controlling interest to a minority interest basis, except for the non-operating assets. The taxpayer, with their 5% discount, however, is suggesting that the results of the discounted cash flow method yielded a conclusion on a controlling interest basis. The court's opinion is a little light here and doesn't really address this fundamental question about what does the DCF method mean in terms of control versus minority. At the end of the day, the court seems to have disapproved of the IRS experts' application of the discount only to those non-operating assets and ultimately sided with the taxpayer on this issue. Finally, we have the discount for lack of marketability. And we all know kind of the benchmark ranges that are often bandied about when it comes to discounts for lack of marketability. The taxpayer and the IRS experts were not very far apart. The taxpayer applied a 25% discount for lack of marketability. The IRS expert actually applied a larger discount for lack of marketability, or at 30%. And as with the terminal growth rate, the court found the taxpayer's analysis of the discount for lack of marketability to be slightly more persuasive than that of the IRS, but just goes to show sometimes you can't win for losing. Despite winning that issue, that was actually adverse to the taxpayer's interest because they had applied a lower marketability discount than the IRS had. Tim, when we think about discounts, when we think about non-operating assets, all of these kind of additional steps that move from an initial indication of value to a conclusion of value for the subject interest, is there a point or two that you think is worth mentioning when you think about those issues in the context of peers?
Yeah, I mean, I think it's kind of the same story we've been talking about here on this webinar, really to have, when you're critiquing an appraisal, to look for that hard capital market evidence. Now, we all know in the lack of marketability, that's usually one of the most contentious places that you see in opinions, and that the tax court has dissected, to a very extensive analysis in past opinions. In this opinion, because the testimony was not materially that different, that's presumably the reason they didn't get into it. But I think, because it is the number one reason why estate planners, such as those of you that are on the call today, um, in your advanced planning for clients, think about transfers of minority interests in privately held companies. Largely the architecture that's used with that estate planning leverages off of the supportable allowances for lack of marketability and lack of control. So, my message, maybe it's the same thing again, but it really boils down to having that hard capital market evidence to the extent you can get it, to obtain it, analyze it in a cogent way, and then most importantly communicate that analysis. Um, as appraisers, we have to be independent and objective, but it's all often been said, independent and objective as to your opinion, but as to your communication, uh, it ought to be a perspective of trying to be persuasive because you want to have the reader or the user of your opinion accept your analysis and conclusion.
Yeah, I think that's a great point, Tim. Your appraisal report should be, you're a vigorous advocate for your conclusion, and that conclusion is independent, but you need to be persuasive and supporting what your ultimate opinion is. All right, so I think with Pierce, there's a little bit of an elephant in the room, if you will, and that is this whole issue of subsequent events. Um, while not really described in the court's opinion, the post-trial briefing makes it very clear that the parties were aware of and were really kind of challenged by the subsequent events in this case. You can see the chart to the left here. This shows actual performance of the company from 2013 before the valuation date to 2019 after the valuation date. So as we've mentioned, the company was on a rapid growth trajectory, and sales had increased to in excess of 20 million in 2013, continued to grow, and were growing at the valuation date. Um, and 2014 sales actually exceeded $30 million. But then sales did decline, margins did deteriorate. A lot of those issues that were identified and discussed in the narrative of the report about things that could go wrong with the business did, in fact, go wrong with the business. And you can see in the chart there, by the time you get to 2019, 5 years after the valuation date, the company was essentially operating at a break-even level, no longer generating any profitability. In 2024, prior to trial, the owners sold the company. They kept the name, but really, when they sold the company, all they got for it was a couple $100,000 worth of inventory. So by the time trial arrived, everyone knew that the company had eventually failed. And, the 2017 forecast that the IRS expert relied upon anticipated this sales decline. Although, that forecast didn't show sales declining quite to this degree. And despite that forecast actually being confirmed by subsequent events, the court said, well, we prefer the 2024 forecast, which, if you recall, in the 2024 forecast, sales continued to grow in 2015 and beyond in subsequent years. But the court found that forecast to be more credible because it was, I think, in part untainted by this view of, or this threat of being shown to be reliant on subsequent events. So, subsequent events it's an issue that is thorny, And we all know the doctrine is simply, hey, if it's known or reasonably knowable, then it can be included in the valuation. But simply saying known or reasonably knowable, that's easy to do, but it's a lot less easy to apply. So Tim, when we think about subsequent events, and both generally and in the context of peers here, what are some thoughts that you might have for our audience?
Yeah, I think you've stated it quite eloquently, Travis. I mean, for appraisers that are preparing valuation reports, and I think the jurisprudence clearly lays this out, that the standard of value for federal tax valuation matters, and arguably for a lot of others too, is what was known on the valuation date or reasonably foreseeable or knowable. And so I think one of the takeaways here is that if an appraiser is using um, events that happen subsequent to the valuation date, it's absolutely critical for them to explain why they were reasonably foreseeable. The other thing is we all know in our reading of tax court opinions over the years, it's in the province of the tax court to look at subsequent events um, because they're the arbiters of value here. But clearly, for appraisers, that's something that they can't do. Look at subsequent events that were not known. Um, I think that's an area that if an appraiser is using a subsequent event, that they've really got to explain that why it was foreseeable.
And in this case, what was reasonably foreseeable kind of speaks to how persuasive was the threat of deteriorating sales from those issues that were noted in the company specific risk discussion, right? The threat of the lawsuit, the potential loss of the destination maternity contract, the company's inability to really jump onto the social media bandwagon. To what degree would events like that, would factors like that, which were demonstrably known at the valuation date, really support a forecast of declining revenue and declining earnings following the valuation date? And that is that's tough to do. But that really requires an emphasis on in the appraisal and from the appraiser's standpoint on being persuasive, as Tim said, marshaling all of that, as much capital market evidence as you can to support the conclusion that the appraisal is putting forth. All right. So as we bring this home, some concluding thoughts. As is sometimes the case, the tax court in Pierce really adopted a what I'll call an atomistic view of valuation, where they break the valuation down into 7 component parts and address each of those parts kind of in isolation from one another. And the opinion never really addresses the overall reasonableness of the conclusion. As we said at the beginning when we showed that chart, the taxpayer, um, their ultimate conclusion of value after discounts and including the excess working capital was $13.3 million for the business, and the IRS was at 19.5. There's really nothing in the opinion where the tax court steps back and says, okay, why do we think 13.3 or 19.5 is more representative of the value of this business? Instead, the court said, we're going to look at 7 discrete issues, and we will weigh in on each of those issues in isolation. And as we saw in a couple of cases, we will side with the taxpayer, even though doing so increases the value of the subject interest. So they clearly are scoring the fight on this issue by issue basis. So was Pierce a win for the taxpayer? Well, I think so. The taxpayer clearly won more of the issues, but the issue that the taxpayer did not prevail upon was material, and that is the use of the company-specific risk premium. So while the opinion doesn't reach an ultimate conclusion of value, the analysis that we can do looking at the opinion and the appraisals suggests that the ultimate conclusion of value implied by the court's opinion is probably on the order of $15 million or so. So a couple $1 million above where the taxpayer was and a few $1 million below where the IRS was. Now, was Pierce a win for taxpayers more generally? I think it's mixed. Tax affecting was affirmed, and that's a good thing. But the experts didn't disagree on that issue, and the court, specifically said they are not setting a general rule. Now, as Tim has pointed out, that really puts the onus back on the appraiser to clearly say why they're tax affecting and why pass-through status is a good thing, a bad thing, or a wash for the company. And the court's opinion really, exhibited a reluctance to accept what are necessarily subjective estimates of company-specific risk. And those estimates are often really critical in reflecting how buyers and sellers actually behave. So courts are always dealing with the evidence in front of them, and courts have approved and have used company-specific risk in the past, declined to do so in this case. That puts the onus on appraisers to be very clear and to marshal as much capital market evidence as they can to support their estimates of company-specific risk when they're appropriate, and to demonstrate why the resulting conclusion of value is reasonable. Tim, what do you think in terms of takeaways for our audience?
Yeah, the Pierce opinion to me really struck a chord with me because it exhibited the tax court's facility and in the in-depth analysis that comes out in the opinion of um, the court's ability, facility to work through the valuation analysis in a very detailed way. And I think this is important for planners because ideally your valuation is going to want to be positioned through its components that lead successfully to the opinion of value. Now, the other thing about it is that it dealt with the income approach to value, which most of you on this webinar know. With a valuation of privately held business interests in operating companies, it's the number one tool in the appraiser's toolbox. And this is the Pierce opinion is instructive because of the diligence that the tax court used to go through all of these issues. And so I think from that perspective, it's really important. It really kind of takes, the look of the entire appraisal process from identifying the business interest to be valued to understanding the fundamental position of the company, its, positive and negative attributes, to obtaining good, hard, sound capital market evidence, analyzing it appropriately, and then probably most importantly, communicating it in a cogent way that will lead to acceptance of the opinion, or again, early resolution on a favorable basis if and when the matter is examined. So I think that's really the broad takeaway from the Pierce opinion.
Right. Thanks, Tim. Well, we've some questions have accumulated in our inbox here. We want to be respectful of everyone's time, so I think we've just got time for one of these. Tim, and I'll pitch this to you, given your experience in this area. And the question is this: what advice do you have about what steps can be taken to really bulletproof a valuation for federal tax purposes?
Well, that really kind of speaks to the issue of what is the attorney's role as advocate for the client. What are their responsibilities? And I would suggest kind of a broad framework of, there's kind of three options. If your objective is to bulletproof, the first option, which is to rely entirely on the appraiser's professional competence to execute things prudently, probably not the best answer, with a caveat, which I'll explain in a minute. The second option, which is a detailed review of the report, subsequent conversations with the appraiser before the report is finalized, and you know, critiquing the appraiser's opinion would be the second option. And then the third option would be based on an ongoing relationship with an appraiser, kind of look at it on a sampling basis. And I think for that third option, and really for all options, the decisions on how you want to look at a report arguably revolve around the materiality of the transaction. If on one hand, we're looking at a annual exclusion gift and the appraisal is being used to support that, arguably the materiality is not going to be really high. Contrast that with if both the husband and wife have interest in the closely held business and are planning to use their entire remaining lifetime exemption, which they have not used to date. I think that leads you to another conclusion. You're going to obviously want to do a more detailed review. So that might be somewhat of a framework to look at when we're reviewing appraisals for gift tax or estate tax reporting purposes.
That's great perspective, Tim. Thanks for sharing that. Well, we appreciate everyone's time, and we have a few more questions that we won't have a chance to get to today, but we will follow up with you and we'll provide our perspective on those questions as well offline. So thanks for joining us, and we look forward to seeing you next time.
Thank you so much for joining us today. If we weren't able to address your question during our session, we will follow up with you individually. The recording of today's webinar will be available shortly, usually within the hour. You'll receive an email with a direct link, so keep an eye on your inbox. If you'd like to reach out with additional questions for Travis or Tim, please scan one of the QR codes on your screen to access their contact information or visit mercercapital.com to get in touch. We appreciate your participation and hope you found today's discussion valuable. Keep an eye on your inbox for future webinars. Thanks again, and have a wonderful rest of your day.